So as I said earlier this morning, we tried to be a little bit fluid with today's presentation. And one of the areas of fluidity was the next speaker. We felt that there was a whole lot going on in the world of HR, especially with regards to the sexual harassment regulations that are coming down the pike. So we brought in Lisa Brauner to speak to you guys today and give you some insight. So Lisa.
Good morning, everyone. How's everybody doing this morning? Good. I'm Lisa Brauner. I'm an employment attorney with the law firm of Perlman Perlman. And this year has been a total whirlwind when it comes to employment law developments in New York and actually nationally. And I'd like to ask you, by showing of hands, how many of you would like to see your nonprofit organization on the front page of the Chronicle of Philanthropy or the 11 o'clock news for sexual harassment? Would you like it? Because we've really seen a year of, unlike ever before, with many nonprofits, for-profits as well, but many nonprofits in the news, headlines splashed across the news for allegations of sexual harassment. And so this is not the only employment law development that's happened this year. I'm kind of going to just give an overview of some major things that have happened this year in terms of legal developments that affect nonprofits. But know that there's more, and that there's more coming. You should expect to see, we're going to continue to see more changes in the law and developments in areas affecting human resources, employment law. So this is, I should just give my disclaimer, which is that this is not legal advice. I can't address a particular scenario that you have, but to kind of just give you an overview of what is happening right now. So you're all aware, of course, we are now in a new era, in a new place with hashtag MeToo. The EEOC, which is up here, stands for Equal Employment Opportunity Commission. That's a federal agency that enforces certain laws that prohibit discrimination in the workplace, including prohibiting sex discrimination in the workplace. A quarter of the litigation that the EEOC brings involves claims of workplace harassment. A third of those the charges, when an employee wants to bring a complaint in federal court, they go to the EEOC first or a state or local agency. And a third of the charges involve an allegation of workplace harassment. More than 80% of those experiencing harassment never filed a formal complaint. And 3 out of 4 who experienced harassment never raised the issue internally. So with everything going on now, the Me Too era that we're now in. This mic? Okay. New York said, what do we do to address this? What do we do to address the fact that people are not reporting it? It's happening, but it's not being reported. So this year, New York State, in their budget, decided to enact legislation that would mandate sexual harassment employers, all employers in New York, to create sex harassment policies and to do annual training for all of their employees, regardless of size. So that's one of the things. So there are a few things that happened as part of this legislation. So I'm going to talk, kind of just give you an overview of what those are. So effective immediately, now non-employees are protected from sexual harassment. So a contractor who contracts with an entity can now make a claim of sexual harassment against that entity. Previously, what was the law was that in New York State was that job applicants and employees could make claims with respect to their employers, but there wasn't an ability for a contractor, and now there is. Did you have a question? Okay.
In the nonprofit world, does that apply to volunteers also? So can a volunteer put a claim in against a nonprofit organization if they feel like it's sexual harassment?
It's a good question. I think one of the things that we're going to look to we were supposed to hear over the next few weeks that New York State Division of Human Rights is supposed to be issuing guidance on the law. And hopefully we will get guidance that considers specifically the nonprofit sector. But I would take a cautious approach. I would take a cautious approach and presume that anyone who's regularly interacting with your organization, that person should be informed about how they go about making a complaint of sexual harassment if it impacts them. So that's one of the things. Now, July 11th, which is right around the corner, New York State has prohibited employers from using, in their non-disclosure agreements in a settlement, with respect to claims of sexual harassment. So you might have heard about this in the news too, that oftentimes when there's a settlement of a sex harassment claim, one of the provisions that the employer gets in exchange for paying money is an agreement that the employee is going to keep the allegations confidential. So now the state says, with respect to sexual harassment, no, you cannot require the person who settled the sex discrimination lawsuit to remain silent, unless the complainant wants to, unless the complainant specifies that they want to keep it confidential. And then, kind of like a waiver and an age discrimination situation, the complainant has 21 days to consider whether or not they're going to agree to the confidentiality provision. And then after they've signed the agreement, they have 7 days to revoke their decision. So also the same date, the use of mandatory arbitration clauses for claims of workplace sexual harassment are prohibited. Yes, you have a question?
I have a comment. That particular provision,
yeah,
except as federally mandated under the Constitution and under the Epic Systems decision by the Supreme Court, I'm pretty sure that's unenforceable.
Yeah, yes, I was going to say that may be unenforceable now that the U.S. Supreme Court. We're going to have to see really how that plays out with the U.S. Supreme Court decision that has said essentially that employers and employees can contract to have an arbitration of claims. That kind of trumps everything. So we're gonna have to see really what's going to happen if something like this is brought to court. So by October 9th, for those of you who haven't heard yet, employers in New York State have to maintain and distribute to all employees a sex harassment prevention policy. New York State Department of Labor and New York State Division of Human Rights are supposed to be working on a model policy and also training. But we have not seen the policy yet, and we don't know when that's going to be issued. So they lay out, and we're going to talk about some of the elements that really need to be in that policy, and your policy needs to meet or exceed whatever the model policy requirements are. So you could, if you don't already have a policy, or if you have a policy that hasn't met these requirements, you may want to update those policies to include the things that we know are going to be required. So the policy has to include a statement that prohibits sex harassment and gives examples of what constitutes sexual harassment, information about federal, state, and local laws prohibiting sex harassment, an actual complaint form, and procedures for timely and confidential investigation of complaints so that there's due process for all parties. Also, the policy has to, yes?
What do you mean by complaint?
So an actual physical form that the employee would fill out that would list likely the nature of the complaint. And I don't know the details of we don't know yet what the details are, if those agencies are going to require certain things to be in that form beyond, but it would be something that you would just attach complaint form for making complaints and, connection with our policy. We don't know the details of what you would have to have really beyond the nature of the complaint or a detail of the complaint. There also needs to be, the question was, what is this complaint form? What needs to be in the complaint form? There also has to be an explanation of what an employee's rights are externally, telling them where they can go if they want to file a complaint, bring a lawsuit, that kind of thing. A statement that sexual harassment is a form of employee misconduct and that sanctions will be enforced against those who engage in harassment and against supervisors who knowingly allow such behavior to continue. I do a lot of trainings on sex harassment prevention, and one of the key things for supervisors is that they actually have a legal obligation not just to prevent sexual harassment, but also to report it. If they fail to report, there can be liability. So, and also a statement that it's unlawful to retaliate against employees who report sex harassment or who testify or assist in related proceedings. These are actually, this is what the law is, and so they're requiring employers to basically put what the law requires into a policy so that employees know what their rights are. Also, by that date, employers have to implement a training program. And the training has to be done annually. And you have to provide an explanation of sexual harassment, specific examples of inappropriate conduct, detailed information, kind of along the lines of the policy, detailed information about what the laws provide, what the remedies are, what the rights of redress are for employees, and where they can bring the complaints, what government bodies they can bring their complaints. So New York City, kind of at the same time, and I don't know if the city and the state were speaking to one another, because I've inquired about, they've got different time frames, and New York City has, for those in New York City, there's an overlay of some additional things. While there's overlap, there are additional things that are required. So Mayor de Blasio signed an act comprised of 11 different bills. Oh, I should also mention under the state provision that if you are a state contractor, by January 1st of 2019, you will need to provide a statement in your bid that you have a sex harassment prevention policy that complies with the law and that you provide annual training as well. So in May, Mayor de Blasio signed Stop Sexual Harassment in New York City Act, and effective immediately, New York City human rights law applies to all employers with respect to sex harassment. So the law generally, New York City human rights law, applies to employers with 4 or more employees. But with respect to sex harassment, just like the New York State human rights law, if you've got 1 employee, you're covered as an employer. You're required to comply with the law. So under New York City's mandate, employers with 15 or more employees need to provide training by April 2019. And September 6th of this year, New York City employers have to post an anti-harassment poster. The City Commission is supposed to be creating this poster, so hopefully we should have it very soon in the next few months. And distribute an information sheet on sex harassment at the time of hire. For new hires, you have to train them within 90 days of when the hire starts. It has to be an interactive training. We don't know exactly what that means at this point, what the scope of interactive is, for all employees and interns. It also mandates a separate training for supervisors, which is recommended in any event because supervisors have additional responsibilities that staff don't have. So it's a good idea in any event. And the training has to involve a bystander intervention component, letting employees know how they can intervene as bystanders. And this poster has to be posted in the workplace, this anti-sex harassment poster. So additionally, employers need to keep a record of who attended the training, get an acknowledgement of receipt, put the date of the training, who did the training, and keep the record for 3 years in the event there was an issue and the agency is now going to come take a look, ask you for information, or in the event of a lawsuit, presumably. And the statute of limitations to bring a sex harassment claim at the New York City Commission has now expanded from 1 to 3 years. There's also in the New York City Human Rights Law an expanded definition as of May 11, 2018 on sexual orientation and gender. They are expanding the definition. So in your employee handbooks, when you have your EEO section and you're talking about the different categories that are now protected from discrimination under the law, you may want to update those to explain the expanded definitions. How many of you have?
Just a quick question.
Sure.
You mentioned the 90-day time period for new employees as of September 6th, a little less than that, as opposed to the annual compliance.
So there's an annual training, and then it's an excellent question. And then,
so for instance, I work for a school and I got teachers starting September 6th.
Right.
The number of new teachers.
Yeah. No, it's an excellent question. So they envision that the training has to be done annually, and it sounds as though what's going to happen is you have a new employee that comes, and that you'll now have to do an additional training for that person. Yeah.
So that's within 90 days of the start
of the person starting. So
But it's New York City only.
that's New York City. That's for New York City. Yeah, that's for New York City.
So if you're a large agency, you have a lot of turnover going on, you're better off just scheduling quarterly training.
You might want to do that. Yeah, you may want to do that. I think that's probably a good idea, because that way you're getting a group of people rather than one at a time.
Question.
Oh, there's a question. Yes. Wait. The last question, just to repeat it for the webinar, was if this 90-day requirement that you have to train new employees, perhaps we should be doing it quarterly with a large organization. And yeah, you may want to do that in terms of efficiency.
Is the training also mandated for board members besides just employees? Board members are they required for sex education training?
So that is not a requirement. However, I will just say I understood the question. The question was sex harassment prevention training, not sex ed. It's not required, but actually I think it's a best practice for organizations to have their boards trained. So first of all, that they know what the organization's policies are about sex harassment, and to prevent instances of sexual harassment from occurring, which we know have occurred involving board members. So I think it's a best practice, even if it's not required by the law.
Hi, I just wanted to confirm this is for all part-time and full-time employees?
All employees, yes. The question is all part-time and full-time, and the answer is for all employees.
I apologize if you're saying this. Does the training have to be provided by a New York State official, or does the trainee have to keep up with online webinar trainings? I'm assuming that laws you put into place every quarter.
They don't specify who has to do the training, and They're supposed to be providing a type of model training. We do not know yet what interactive training means. In other words, I personally think live training is best because you have the chance to interact, answer questions. People are more focused and paying attention to what's going on than the video training. But video training might be, it's just going to depend on whether it's interactive. And right now, we don't have guidance yet on what's going to qualify as interactive. You know, is it going to be enough to just press a button on a multiple choice? We don't know if that's, we don't know. But there's no specification in answer to your question of, are there specific trainers that need to be used? No, they're not going to require. You can use, you know, your HR person, your employment attorney, whomever. They're not specifying. They're just saying the training needs to be done. So how many of you have heard about this, the cooperative dialogue? Everybody probably knows that in New York State and New York City, and federally, employers have an obligation, they're covered under the laws, they have an obligation to reasonably accommodate disabilities and religious practices at the federal level. But anyway, at the local level, we have a number of, under the New York City human rights law, employers have a duty to reasonably accommodate not just disability and not just religious practices, but also pregnancy, childbirth, and related medical conditions, domestic violence victims. And so that's been the law. So what's changed? Well, there's a heightened requirement starting in October where you will have to you have to engage in a cooperative dialogue, which is just like the interactive dialogue that you had to before, right? But you now have to document and provide to your employee a written determination of whether you've granted or denied their request for a reasonable accommodation. So you may want to create a form where you're documenting the steps that you took to engage in an interactive process with that employee to determine a reasonable accommodation. And who's covered under the law? Under New York City human rights law, employers with 4 or more employees. So specifically what is said is that employers who are covered by the law have to engage in or seek to engage in a cooperative dialogue with individuals who may be entitled to such accommodation in order to identify where reasonable accommodations are available to assist them. So these are the requirements for New York City. And a dialogue has to occur within a reasonable time. I don't know precisely what that number of days is, but a reasonable time of receiving a request for an accommodation or notice that an accommodation may be required. So what does this mean? It means you have to have, your dialogue has to consist of the following, and this may be useful to you if you're going to create a form yourself with your HR person, your employment attorney, whomever, that addresses the following things. What are the person's needs, accommodation needs? What are potential accommodations that may address their needs, including alternatives to the requested accommodation, and the difficulties that such potential accommodations may pose for the employer. And one of the reasons why this is so important, documenting this process, is that in recent years, these cases involving a failure to accommodate a disability have focused very much in New York City and state on not so much whether the person has a disability, because there's a very low threshold in New York City for what's a disability, a physical or mental impairment. It's focused on whether the employer engaged in an interactive process with the employee. Did they sit down with the employee and actually have a discussion with them? And where the employer failed to do that, that's a violation of the law. So it's very important, it's actually crucial. And so now this is why this is now codified in law, that the employer is in fact engaging in this process and documenting what you need to document under the law is you have to provide the written determination. But the other things are helpful in terms to document so that you can show, in the event that there were a lawsuit and you were defending your decision as to what you did, you would have a record of the steps that you took in engaging in this process. So a written determination, what's required, written determination to the person who requested the accommodation, identifying the accommodation that's been granted or denied, a determination that no reasonable accommodation would enable a person to satisfy the essential requisites of the job. That, if you make that determination, that can only happen after you've engaged in this dialogue. And significantly, this legal obligation does not, to engage in the dialogue, doesn't have to be prompted or initiated by the accommodation request. So essentially, and we'll see how the courts interpret this, if you have noticed, if you have an idea that this person may need an accommodation request, you can have that dialogue without the person necessarily saying, I need a request for an accommodation. I mean, I'm making a request for an accommodation. So for those of you with operations in New York City, you may be aware of New York City's paid sick leave law. That was amended in May to now provide safe time. So that is, you can use those 5 paid days of sick leave now for leave for domestic violence victim to take time off, paid time off, to get services from domestic violence shelter, to participate in safety planning. Now, you should know New York City already has an existing reasonable accommodation requirement for victims of domestic violence. What this does, essentially the change is that the employee now has paid time, and they can use that paid sick time for safe time. They can use the time to meet with an attorney or social service provider, file a domestic incident report, meet with the district attorney's office, those kinds of things. And just as a refresher, it's 40 hours per calendar year. New York City employers with 5 or more employees provide the paid leave. If you've got fewer than 5, it's unpaid leave, and 1 hour of leave for every 30 hours worked. So this is just more information that you have in your handout just about the notice of employee rights. Just as with that annual notice of pay rate that everybody is required to provide to your employees in New York in English and in their primary language, that you provide to your employees when they start working, this notice also needs to be provided. And there's an updated one on the New York City Department of Consumer Affairs website. You need to provide it in English and in the employee's primary language. If that language is listed, the notice is listed in one of the model sheets on the Department of Consumer Affairs website. So if the person's primary language is something that the Department of Consumer Affairs hasn't created a notice for, you don't need to provide it in that language, in their primary language. You could provide it just in English. But if it's up there, you need to provide a copy in their primary language as well. And the notice needs to be provided, just like with the notice of pay rate. You need to provide it on the employee's first day of work or by June 4th, whichever is later. So this is just really just kind of a refresh on where we are. The minimum wage in New York, you know that it's going to be going up to $15 over time. And currently it's for New York City large employers, those with 11 or more employees, $13 an hour, going up to $15 an hour at the end of the year. I don't know if anyone has questions about that. Long Island and Westchester, $11 an hour, going up to $12 an hour. And New York City small employers, 10 or less, currently $12 an hour, going up to $13.50 an hour. For those of you who may be aware, you may know in terms of figuring out, are my employees entitled to overtime pay or not entitled to overtime pay? For employees that you have classified as exempt from overtime, meaning they're not entitled to overtime under either an executive or administrative exemption, they also in New York have to meet a salary threshold. They have to meet a salary threshold, and then they have to also meet the duties tests of those two, of one of those two exemptions. So there's salary thresholds; those are listed here. In New York City, for 11 or more employees, it's currently $975 a week, a salary of $975 a week. For in New York City employers with 10 or fewer employees, it's $900 a week. In Nassau, Suffolk, and Westchester counties, it's currently $825 a week, and the rest of the state is $780 a week. And that's obviously, it's going up at the end of the year and will continue to do so, at least for the other parts of New York City, for smaller employers, and for other parts of the state. As you all know, New York's paid family leave took effect January 1st of this year. It provides partial wage replacement and job protection. So just like the Family and Medical Leave Act, it applies job protection. It applies to all employers in New York State, for the most part, regardless of the size. And it provides some paid time off for work for a few different reasons: to bond with and care for a newborn, adopted, or foster child during the first 12 months following birth, adoption, or fostering the child; to tend to obligations arising from a spouse, child, domestic partner, or parent who's been notified of an order of active military duty; and to care for a close relative with a serious health condition. One of the things that's different than the Family and Medical Leave Act, for those of you that may be covered under that, is under the FMLA, you can use that time to care for yourself. That's not the case under the paid family leave. You can to care for a close relative with a serious health condition, but not for your own care. So who's eligible? Employees after 26 work weeks, if they work a regular schedule of 20 or more hours a week, or after 175 work days, if they work a regular schedule of fewer than 20 hours a week. And this is going to be, the paid family leave is going to be staggered over time. So this year, employees are eligible to up to 8 weeks of paid family leave, where they get up to 50% of their average weekly wage, so long as it doesn't exceed the New York State average weekly wage. So that's how it works. And eventually, in 2021, it'll eventually increase to 12 weeks of paid leave, and at the same time, the percentage of pay that the employee will get will increase to 67%. This is, as you probably know at this point, since we're now in we're in June, and so you've had this for a while. You know that this is funded through employee paychecks, through deductions, just like you would have with short-term disability. So it's, as you know, a rider to the short-term disability policy. The New York State Department of Financial Services established the contribution for coverage, and that amount gets deducted every pay period from the paycheck to pay for the premium, essentially. And a new rate will be established every year. So generally, does it apply nonprofits? Yes, generally, but coverage restrictions for disability benefits for employees of nonprofit or religious institutions also apply to paid family leave. And excluded from mandatory coverage are persons that are engaged in professional teaching for religious, charitable, educational institution, or executive officer. These are certain exceptions. So if short-term disability applies to you, then this will apply as well. Essentially, it's a rider on your short-term disability policy. What about notice? Do employees have to give notice under this if they want to take paid family leave? If it's foreseeable, if they know the reason that they're going to be taking it, then yes, they need to provide at least 30 days advance notice before the leave begins. And documentation can be required. Typically, they're going to submit a form. They're going to submit it to your insurance carrier with the required documentation, depending on what the reason is that they're taking the leave. And employers significantly, like the family and medical leave, like the FMLA, employers need to continue the health insurance of employees during this period, so long as the employee is continuing to pay their share of the premium during the coverage. And just like the FMLA, this is a job restoration requirement. So you have to keep that position for the employee, restore them to the position following the end of the leave, like the FMLA. So at the federal level, and this is where I say we're going to probably see, I don't know if we're going to see the most changes, but we are going to continue to see, I think, significant changes in the labor and employment area with employers, with more, I would say, more pro-employer rulings we're going to see. We're already seeing them. So the NLRB stands for the National Labor Relations Board, covers most employers, union and non-union. And under the last administration, there were some significant changes that the NLRB imposed on employers, specifically with workplace policies and rules. So policies that employers had had for years, standard policies on respect in the workplace towards your colleagues, not using organization logos without permission, and other things like that had for years been in your employee handbooks. Well, under the Obama administration, there were a lot of changes with the National Labor Relations Board, where the board went after both non-union and union workplaces for policies that they said violated the National Labor Relations Act, in that those policies were chilling the rights of employees to engage in what's called concerted protected activity, to unionize, to discuss terms and conditions of employment. They said those policies could be construed by employees as inhibiting their rights or chilling their rights that they have under the National Labor Relations Act to engage in these activities that I mentioned. We now have a new Labor Relations Board under the Trump administration, and things are changing notably in favor of employers, I would say. So now, significantly, the NLRB, when it's looking at a policy, will look at the employer's business justification for why they have a policy and events that might explain the impact of the rule. And they will consider those things and weigh those things, and that's really significant. So in the past, any rule, any workplace rule that employees have reasonably construed the language to prohibit Section 7 activity was an unfair labor practice. Section 7 activity means it's under Section 7 of the National Labor Relations Act is the right to engage in this concerted protected activity for the things that I mentioned, like organizing and complaining about your wages and complaining about health and safety conditions, those kinds of things. So in the past, I don't know if you're aware of this, but under the Obama administration, there were changes where having something in your handbook that said, you know, you may not be disrespectful, or you may not use loud and abusive and foul language in the workplace. Those things, those kinds of things were found by the NLRB to be unlawful, to violate the National Labor Relations Act, to violate and to chill, because they, from their perspective, it was chilling the employees' rights to speak up, and potentially an employee might interpret that as that they can't speak up against their boss if they feel like if they feel like they're being mistreated with their wages. So in the past, things like under the Obama administration, provisions in your handbook that said loud, abusive, or foul language, or an inability or unwillingness to work harmoniously with employees, or negative conversations about managers, and things like that, were all found to be unlawful. You might have also heard in the news of even stories about employees posting on social media about their supervisors and then being fired, and the NLRB saying that was unlawful, they were exercising their Section 7 rights. So there's a big change. So in December of last year, in a case called the Boeing Company, the NLRB overruled this previous standard of reasonably construe. saying that that standard prevented the board from giving meaningful consideration to real-world complexities associated with many policies, work rules, and handbook provisions. You know why you have I need to move along here. So, kind of in a nutshell, the NLRB is going to be looking at business justifications, which means you may have, as an employer, greater support in defending reasonable, common sense provisions to maintain order in your workplaces, to set civility in your workplace. So for instance, in the past, rules that required coworkers to be civil to one another could be found to be unlawful. So that's not the case now. That's no longer to be unlawful. So the General Counsel of the National Labor Relations Board recently issued a memorandum, which if you're interested, you can all find on the NLRB's website, where the General Counsel says, here's the new world order, here's what's happening now, and here's how this is how we're gonna view things. We're looking at 3 categories of rules and handbooks. Rules that are generally lawful, and I wanna share those with you because you may wanna be updating your handbooks to reflect these changes that are significant. Rules that warrant individualized scrutiny, which are, we're not really sure whether it's lawful or not. We're going to actually have to look at the rule and see whether whether we think it's going to chill an employee's Section 7 rights. And rules that are just unlawful to maintain. Does anyone have a sense of a rule that might be just outright unlawful to maintain? Well, do you know that it's unlawful to tell your employees not to discuss compensation in the workplace? Now, with some exceptions, you have people that deal with compensation, like HR, right? But generally, you can't tell your employees that they can't discuss compensation. So, an example of a rule that would be unlawful is a confidentiality rule, and some of you may have these already, but a rule that says confidential information includes employee wage information. No, because employees have the right to discuss their wages. So let's talk about things that are lawful so that you know when you're going to update your handbooks, what things do I know the NLRB will give its stamp of approval. So these are things that are generally lawful because when they're reasonably interpreted, they don't prohibit or interfere the exercise of rights guaranteed under the NLRA. Or because the potential adverse impact on protected rights is outweighed by the business justification. So if you have a strong business justification, you may be able to defend your policy. So, number 1, and this is really significant, civility rules. Rules about insubordination. You were limited in terms of rules of insubordination. Now these are lawful. You can have a rule that prohibits insubordination. You can have a rule that says no photography on your premises and no recording. You can have a rule that says, now, I'm saying this kind of broadly. I'm saying this broadly. Obviously, if you have unions, there may be certain things that you've negotiated with them. But this is what the NLRB is looking at. Civility rules. You can have civility rules. You can have rules about disruptive behavior. These are significant changes. You can have rules protecting your confidential and proprietary information. The question is, how are you going to define what's confidential? You can have rules prohibiting defamation. You can have rules that prohibit the use of your logos and intellectual property. Rules requiring authorization to speak for the organization, and rules banning disloyalty, nepotism, and self-enrichment. These are okay. Rules that might now involve individualized scrutiny, broad conflict of interest rules, as I said, confidentiality rules encompassing employer business or employee information for the reasons that I mentioned. Why would that require individualized scrutiny? Because they want to make sure that this employee information, it isn't things like wages, compensation, things like that. So other rules that warrant individualized scrutiny, rules banning off-duty conduct, rules banning false and inaccurate statements. And then things that are unlawful, as I said, confidentiality rules regarding wages, benefits, working conditions, etc., and rules that prohibit membership in outside organizations or voting on matters concerning employees. Those are unlawful. Why do you think? Second one's unlawful, right? Because this could chill an employee from thinking that they can't, that the employer's telling them they can't join a union, right? So some other, I'm going to go very quickly because I know my time's running out. The U.S. Supreme Court has historically viewed, when you're trying to determine whether an employee is exempt or non-exempt from overtime pay, historically under the Federal Fair Labor Standards Act, the Supreme Court has narrowly construed exemptions. Not the case anymore. Now they're going to apply a fair test. What that looks like, we don't know for sure, but we do know that means it's going to be more of a pro-employer stance. There was someone in the audience that mentioned this case. This is a significant case that just came down from the U.S. Supreme Court. Essentially, there were three cases, but the gist of it was there was an issue about employees had entered into arbitration agreements with their employer, individualized arbitration agreements. Then one of the employees who signed the agreement sued in court for under the FLSA, saying he had been misclassified as exempt from overtime, when in fact he was not a non-exempt. That was his argument. And he said that he's part of a whole class of people who are all affected. Well, he said that his agreement, the company said, no, you signed an agreement that you agreed to arbitrate only your claims. You can't bring in a whole class. You've waived the right to bring a class action. And the employee said, well, no, I don't really think that that's okay because the NLRB says that I can, that these are unenforceable and this is concerted protected activity to get together as a class. And the Supreme Court agreed with the companies, disagreed with the employees, and said no. The Federal Arbitration Act says that employers, employees are free to enter into arbitration agreements. That's what governs, and employers can require employees to enter into arbitration agreements where they agree only to arbitrate their claims and to waive any class or collective actions. Those are lawful. So this is a significant decision. And I'm going to scroll through. UBIT was addressed, you may know, for nonprofits that pay compensation of $1 million or more to any of the five highest paid employees, that there's now 21% excise tax on those amounts over $1 million. So that's something new. We already talked about that. And I'm just going to wrap up right now. I know I've probably run out of time with just a few best practices, just a few things. So, first of all, the way I started out was really talking about the sex harassment mandates, sex harassment prevention mandates, both the policies and the trainings. So I would say, as a first order of business, you really may want to go back and look at your policies, look at what the state requires, and if you're in New York City, what New York City is going to require, and update those policies. Even though they haven't issued the model policy, you can still start doing some things to incorporate what we know they're going to require. Make sure you set up your trainings. Make sure that you have training set for your employees and an additional training for your supervisors that's going to comply, and that if you're in New York City, you're incorporating bystander intervention training. I would just say also, and while you're at it, train your managers on other things outside of sex harassment. Like if they're in New York City, this obligation of the cooperative dialogue for accommodations. And even if they're not in New York City, educate them, train them about the reasonable accommodation requirements in any event. So update your handbook policies, make sure that you're incorporating all of these things, that you've got the SAFE Act provisions if you're in New York City updated. If you have non-disclosure agreements, make sure all of your forms, your templates, and everything are consistent with what the law now requires. If you haven't done a self-audit of your worker classification, make sure you check that. I see over and over again, clients come to me and we start talking about which of their employees are exempt or non-exempt, and they say, don't worry about it. All of our employees are salaried. You don't need to worry about. I said, yeah, they're salaried, but who's exempt and who's non-exempt? Everybody's exempt. They tell me, everyone is exempt. They're all salaried. So sometimes it's not unusual that I'll find that clients assume incorrectly that because someone is getting paid a salary, they're not entitled to overtime pay. So it's, you know, exempt employees, they have to be paid a salary, but there are duties tests that will determine whether or not they're exempt. The fact that they're salaried doesn't mean that they are necessarily exempt. So if you haven't already done it, you should really be looking at your workforce and figuring out who's exempt and not, or non-exempt, updating your job descriptions, which will help you determine that. Make sure you know who's a volunteer and who's an employee. Make sure that you've done an analysis of pay equity. Are men and women getting, are they being paid the same for the same job that they're doing? And as I said, be aware of legal requirements and the interactive process. That's important both at the state and New York City level. And so I have here, that's basically wrapping it up. Don't fire an employee without documentation. And finally, don't end up on the 11 o'clock news. So thank you.
Thanks a lot, Lisa.